this pink area is an expansion of Zone B. So now instead of ending at offense level 11, it's going to expand all the way up to 23. So
That's
they're
great.
basically doubling it, doubling certainly doubling the
Yeah.
number, but it's going to capture more than double of
Yeah.
the defendants. It's going to capture all these people from 14 to 23 that are in Zone D right now will be in Zone B. So they're going to go from a presumption of prison to a presumption of probation.
It's
That
amazing.
is huge.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. It is a Friday afternoon. It is February 20th, 2026. It is a lovely, brisk winter's day here in Phoenix, Arizona, and I am on with my great friend and colleague, Mark Allenbaugh, again for another thrilling episode of Set for Sentencing. Hello,
Yes,
Mark. How
thrilling.
are you?
I'm doing well, Doug. Ready to be thrilled and to thrill.
Oh, good. Well, I know you are, and we're going to be talking, in case everyone's curious, well, a couple of current events, but really we're doing this because we are the geeks that actually sat through hours and hours of live streamed hearings at the United States Sentencing Commission this week, where the commission is considering some really significant changes to the guidelines. We touched
Yeah.
on some of them on our episode with Professor Berman a month or so ago, or maybe on the new year, but there's more to talk about. And that's what we're going to do today, because really, if these amendments go through, and we think they will, it will be, I know we've said seismic shift before, and I don't want to be the boy who cried wolf, but I think this will be the seismically
Yes. Yeah.
shiftiest shift of that we may have ever seen. So stay tuned for that. But first, I will say, I don't know if our listeners will be happy or sad about this, but I have a hard stop in 1 hour because it's 1 hour
Okay.
because I have a special guest coming, not for the podcast, but my son's high school friend apparently is doing some sort of project on the First Amendment, and he is coming
Oh,
to the office to interview me on that subject.
oh, wow.
And
Nice.
this is how by the way, the young people talk who are seniors in high school. Yo, yo, what is cracking, Mr. Passon? That's
What
the
is
greeting.
Crackinson?
Yo,
Okay.
yo,
Yeah.
what's cracking, Mr. Passon? Anyway, we set up a time, and he says, "Yes, baller, I got you." GOTCHU exclamation point.
Man.
And like,
Oh, wow.
yes, baller, I got you.
Yeah,
So
my
yeah.
kids, my kids, I mean, I make my kids' friends refer to me as Mr. Allenbaugh. Man, if anyone called me baller, I'd kick them in the nuts.
Well, he did say, "What's cracking, Mr. Passon?" And then
True. Okay. Mr.
I
Passive is
and
good.
I,
Yeah.
I I I imagine baller is a compliment in these children's universe, but I'm gonna hope
Yeah.
so. But in any case, so hard stop, First Amendment.
Okay.
I have no idea what that's going to be about. Secondly, because I have a nice young high schooler coming to the office, I won't be drinking tequila for this. It is Friday
Got it.
afternoon. Normally, I would already be cracking out the tequila, but being the baller that I am, I decided to just hold off till maybe
Right.
this
A
evening for
sober
that.
baller. Yeah.
Plus, I may
There you
be
go.
having a nice evening stroll with my bride, and I don't want to
Nice.
start drinking tequila before that. So,
Yeah.
table tequila for next time. Now we're going to
Okay.
move to the current events portion, because today was
Yep.
a very very big day with
Yes.
a very big ruling from the Supreme Court that seemingly on its face has fuck all to do with what we talk about on Set for Sentencing, but we think maybe it has everything to do with what we're talking about. And so why don't I throw it to you to tell our lovely listeners what we're talking about as if they don't already know.
Okay. Well, this was the tariffs case that we've all been waiting from the Supreme Court to hear about. When Trump first became president, as we all know, he wanted to set a bunch of tariffs, pretty outrageous ones. Some of them were like over 100% on a bunch of countries, and he used it as political leverage and blah blah blah. Anyway, the real issue is, did he have authority to do that? And this was the case of learning resources versus Trump. And the question was whether the president had the authority under, what was it called, the International Emergency Economic Powers Act, or IEPA, as they call it in the press, whether that gave him the authority to issue tariffs. Generally, traditionally, it's only been Congress that had the authority to issue tariffs because it's a tax. And one of the things that Trump was kept saying is, "Oh, tariffs aren't a tax. We're raising money for the country." Well, the Supreme Court put that to rest today, and no, tariffs are a tax. They said, and they wrote that. And what they came up with, what they decided, and it was a 6-3 decision, was that Trump did not have the authority to issue these tariffs under the statute. And what does that have to do with sentencing? And what does that have to do with, federal criminal law? Well, as some of you may know, Doug and I have been litigating this particular issue, as well as many others, out in the District of New Jersey
Yes. Well,
regarding,
let
yeah,
me break in because I'm
yeah,
going to preface what you're about to say
yeah,
by reading a post that I put on Facebook. I actually
ah,
forwarded your post about
yeah,
the tariff case, and I said,
yeah,
because this is going to set you up, this is going to tee
yeah.
you up, brother.
Oh, team me up. Good, good, good.
For those paying attention, this is a very significant ruling and a very hopeful day for America because this isn't about tariffs. It's
Right.
about power. It's
Bingo.
about whether our system of checks and balances, so brilliantly designed by our founders, still holds. Today, we learn that it does. Trump is no king. He doesn't have a blank check. He can't do what he wants when he wants. Today, the court told him as much. Let's celebrate that win and hope for many more to come.
Right.
So, why is this about power, and how does that relate to the litigation that we've been fighting in the District of New Jersey regarding the illegal appointments of U.S. attorneys?
Well, so it has to do. So with respect to the legal appointment of U.S. attorneys, Congress gave the president. Well, first of all, Congress is the one who created the U.S. attorneys, the position of the U.S. attorney, and all the U.S. attorney, the 93 that are out there, as well as the attorney general. Congress created those positions actually at the same time, back in the 1700s. And since that, for the first 80 years after Congress created different U.S. attorneys' offices around the United States and the attorney general, those were completely separate entities. And then after about 80 years, then a Congress decided, okay, we're going to put the U.S. attorneys nominally under the attorney general to kind of direct and manage litigation and policies and all this other stuff. But nonetheless, still keeping the U.S. attorneys largely independent. And,
Did you learn nothing from our hour spent with Dr. Randy Olson about concise,
oh,
clear and
concise. Yeah,
concise
no, I didn't.
communication?
Sorry. I'm really
Let's
worried.
let's
So,
do this is why we work so well together
yeah,
because Mark gets into the weeds and the details
yeah,
and I'm the story guy. But
yeah.
let's do the ABT. What's the real problem here? The real
It's
problem is
power. Yeah,
there
it's
are
power.
laws
Power.
in
Yeah.
place.
Right,
There are laws in place and constitutional requirements in place, but Trump doesn't give a fuck about following the law.
right.
And the tariff thing is a perfect example of that.
Yeah,
He did these tariffs under some Emergency Powers Act, and the court said no. And then this issue about what's the doctrine that was at play in the tariffs case about. Uh,
Called the major questions doctrine.
the major questions doctrine. So let's
Yeah.
talk about the major questions doctrine in a sentence. Tell us, what is that and why was it implicated in this case? You can do it in less
The-
than a sentence because you already
okay,
did it
do
with
less in
me
a
today
sense. Okay, well, I'll
with
just
Carl
say
Sagan.
you're right. The major questions doctrine should be called the Carl Sagan doctrine. And Carl Sagan is famous for saying the more extraordinary your claim, the more extraordinary your evidence needs to be. And the major questions doctrine says the more extraordinary the power you assert as the president, the more you got to point to where you're getting that authority. You got to prove it. You got to prove that Congress explicitly gave you this extraordinary power. And in the context of what we have been talking about with U.S. attorneys, the president has been claims to have this extraordinary power where he himself doesn't need congressional approval, doesn't need Senate confirmation for anybody. He can just appoint whoever the hell he wants, whenever he wants, for as long as he wants as a U.S. attorney. And that's what he's been doing. He's actually been doing that around the country because he wants people in place that will rubber stamp and do whatever he says. He doesn't want anybody out there who's independent, thinks for themselves, follows the law. He did this most famously with respect to Lindsey Halligan when he wanted to go after Comey and Tish James and the Eastern District of Virginia. No line attorneys, no career prosecutors were going to take this case. They weren't going to indict. So he got an underling, a yes woman, Lindsey Halligan, who had no experience in federal criminal matters. He had her come in. He didn't send her to the Senate for confirmation or anything like that. No, he just said, "You're the U.S. attorney. Go indict these people, harass them," and that's exactly what she did. And then she ended up getting kicked out, just like Alina Habba did, because in order for you to be the U.S. attorney, now there are certain exceptions, but generally you have to be confirmed by the Senate.
Yeah.
And
So the problem is Trump doesn't give a shit about that.
Right.
And then when there's vacancies, there's this very, very clear federal statute that says the judges have the power to appoint, at least fill the vacancy until there is a Senate appointed thing, and they don't care about that either. Now, today I heard Trump crying, whining about the Supreme Court tariffs case and also saying, well, I'm going to just do tariffs I'm going to try this other statute because I'm going to do it. So this is exactly what he's doing in the context of the U.S. Attorney's Office.
Right.
You know, the Court of Appeals for the Third Circuit very clearly said, Alina Habba, you're fired. And they said, well, I guess we'll put in 3 people in her place instead of 1. And so they're constantly trying to find ways to circumvent the law. And I was just very happy today, especially the Supreme Court, because you never know which way that's going to break, given the composition of the court, that a 6-3 decision said, no, there's still checks and balances. This is the law, and you have to follow it. So to me, that's a very, very hopeful sign that our constitutional republic is still holding for now.
Right. And you know, and there's a lot of controversy about the major questions doctrine that I won't get into because it doesn't comply with the story. But what I like about it though is because it is Carl Sagan and what Trump and his underlings that have been trying to usurp the role of Congress in appointing U.S. attorneys have been doing is just saying what they do is they look for gaps in the law or where the law is silent. And they say, well, the law doesn't say we can't do this, so therefore we can. And what the major questions doctrine says, no, especially in cases where you're asking or claiming to have a lot of authority, you must prove where the law says you can. And it must clearly say you can. You can't just go and say, well, it doesn't say this and it doesn't say that, so therefore I can. No. You got to affirmatively show. And that's what, and I think was, and Gorsuch notes this in his concurrence in the case, how the whole point of the major questions doctrine is to keep the executive at bay, to prevent what he called the encroachment of executive power on that of the other branches, namely Congress in this case. And for our case, with respect to the judicial branch, once the Congress gave judges the authority to appoint a U.S. attorney where in cases where the time for the president to do so has run out. because there has to be a U.S. attorney in place. And so judges could go in and do it. And now twice, the day that judges have appointed U.S. attorneys, on the very day that of those appointments have gone in, Trump has now two times fired that attorney the same day. First was in the case of Elena Haba or Desiree Grace, District of New Jersey. And then I can't remember the gentleman's name from, I think it was just last week.
Yeah,
in
New
the
York.
Northern District of New York.
Yeah. Not only did they fire him, but Todd Blanche then put a tweet out saying the president gets to appoint U.S. attorneys, not the judges. Well, sorry, there's a statute right on point. So, I hope that I hope that the judges keep holding them to these standards, and I think that today was a hopeful day. And good news is nice. Sorry. Yes, go ahead.
I just want to read just the opening paragraph because it's beautifully written. And by the way, I think Gorsuch, and I don't care if people hate me for saying this, I think he's the most brilliant justice that has ever been on the bench.
I thought Roberts wrote the opinion.
He did. I'm reading from Gorsuch's concurrence.
Oh, good. Okay.
Yeah. So this is Gorsuch's concurrence opening paragraph. The president claims that Congress delegated to him an extraordinary power in the International Emergency Economic Powers Act, the power to impose tariffs on practically any products he wants from any country he chooses and any amounts he selects. Applying the major questions doctrine, the principal opinion rejects that argument. I join in full. The Constitution lodges the nation's lawmaking powers in Congress alone, and the major questions doctrine safeguards that assignment against executive encroachment. Under the doctrine's terms, the president must identify clear statutory authority for the extraordinary delegated powers he claims. And as the principal opinion explains, that is a standard he cannot meet. Love it.
Yeah. The only question is, what's he going to do next? And will he follow an order? And most importantly, what would be the consequence for him not? And that's, of course, the big question, because an order is just an order and doesn't mean anything.
Well, we know that they've not been following a lot of orders,
Right. Well, they just went through that in the District of New Jersey, 50-something like 56 orders
70.
ignored. 70. Okay. But I saw I think I forwarded you this in a District of Minnesota case. A judge is now imposing a $500 a day sanction on the U.S. attorney in an immigration case until they come up with the documents they stole from this guy, like ID and things like that. And so take a page out of that book, Your Honors. And these are line prosecutors. They're responsible. They're doing the bidding of the Trump administration. They've taken their spoken or unspoken loyalty oath, and now they need to pay the piper. You have lawyers in front of you in your court that are blatantly disobeying your orders. So what are you going to do about it? That's the question.
Well, many of them are quitting.
Yeah, well, good for them. I would have quit a long time ago, and I'm glad they are. So, and then I guess we can't go without the other current event, which is I guess it's the Epstein files, but really what I love is the post. I think you made the post that about the X file. Did you? Was that your post?
Oh, yes, I mean
that was very clever. Tell our listeners what you said.
Right. So Trump, I think it was yesterday. Trump late sometime yesterday, he announces that he's releasing all the files of all the UFOs and all the extraterrestrials and all this stuff. So I said, well, he won't release the Epstein files, but he'll release the X files. So that's just another stupid thing at distracting, just distraction. I think he's just trying to frankly, I think it was him, combination of distraction from the Epstein files, but also to try to one up Obama again, because Obama had said something about, he was interviewed recently in the last few days about UFOs and extraterrestrial life, and he made some comment that blew up. And so I think Trump was trying to steal his
Oh,
thunder there.
oh, because I did read something that Trump was mad at Obama and said he shouldn't have done that. That's probably what he's
Yeah.
talking about.
Yeah.
What
That's
a
what he's talking. That's
whiny,
what he's talking about.
what a
Yes.
whiner. Well, anything to distract from
Yeah.
Epstein. I'd rather have the X-Files than a war with Iran. I gotta
Oh
believe
God.
Trump's a little bit happy about the Supreme Court opinion today, because at least that's the only thing the news is talking about are tariffs today.
Right.
So that
Right.
he
Which
got
he
a
has to pay
one
all
day.
that back. All the trillions he stole from us.
From us. I know. We should
Yeah.
start a class action lawsuit. I'm trying to
Yes.
think about what I paid more for under tariffs, because Mike, interestingly, tequila really didn't go up. That was somehow immune from that, so I don't know. But anyhow, I suppose since we're here to talk about guidelines, it may be time to turn your
Maybe.
attention to this. But this is just we do the hard work so you people don't have to. I was listening to and it started at like 7 a.m. my time on, was
Mhm.
it the Monday of this week, where these
Yeah.
hearings start, and very good people doing very earnest work, but it is
Yes.
kind of like watching paint dry in a lot of ways. And so, I sat through as much as I could, and you sat through probably all of it because you're the king of all guideline nerds. But when I was sitting into it, I was waiting to hear about, all these economic crime guidelines, but all I heard about for the longest time was meth, meth, meth,
Right.
meth, meth,
Yes.
meth, meth. And so I actually did pull a clip from the testimony that I thought might be interesting to sort of set this up here. If I could just share my screen real
Yeah.
quick.
Who the hell are you?
You know.
That's good.
You all know exactly who I am.
Yeah.
Say my name.
You what?
Love the show.
I don't have a damn clue who the hell you are.
Yeah, you do. I'm the cook. I'm the man who killed Gus Fring.
Bullshit. Cartel got Frank.
You sure? That's right. Now, say
Say
my
my
name.
name.
Yep.
Heisenberg.
There you go.
You're goddamn right.
Okay. So
Great show.
this was all about purity, meth purity, and it sort of harked
Mhm.
back to the crack guidelines, but we really aren't going to talk about that. I think
No.
they'll make a change that'll be helpful and balance that out. But the truth is we're not handling a lot of meth cases. I don't know if we've ever had a meth case together. I've had
Mhm.
plenty of them back in my day as a federal defender. So I really want to get to the big one, the one when I promised seismic shift. And by the way, they didn't even talk about this in the 2 days of hearings. You told me they're going to be
Well, they haven't had the second day yet. That's on March 9th.
okay.
Yeah.
So they didn't
They're-
talk about this in day one. There's going to be a follow-up on March 9th, and that is important for everybody because this is such a big deal. And that means, you've got some time to weigh in,
Yeah.
the comment period. And it doesn't necessarily have to be before March 9th, but it has to be before April when they make when they vote on them, right?
Yeah, but the comments should be in before March 9th.
Okay.
They do want
Well,
them
good.
in before the.
So I'm glad we're talking about this, and I'm
Yeah.
glad they haven't discussed it. But what are we talking about here? Tell us.
You mean the zones?
Yeah. Give
Yeah.
us the headline.
Okay. Wow. So this is a paradigm shift. I'll put it this way: before the guidelines, 40 years ago, before the guidelines went into effect, most nonviolent first-time offenders received probation.
Yeah.
By most, I mean like 3/4, actually a little bit more than 3/4. You and I have a article in Law 360 coming out on this.
Mm-hmm.
Now,
Which
since
I'll
the guidelines,
try to make available for download when it comes out in the show links.
Yeah.
So headline. Sorry to interrupt. Okay.
Yeah.
Used to be before the guidelines.
Used to
most
be,
people
so
got
it-
probation.
most people got probation since the
But-
guidelines came into place.
But
Prison.
prison. Everybody goes to fucking
Everybody
prison
goes to
after
prison.
the guidelines.
Everybody goes to prison. Well, I should say everybody. Over 90% of, maybe close to 90%, I should say over,
Yeah.
but close to 90% of all federal defendants end up going to prison.
Which
And
is curious given the stated congressional intent when the guidelines went into effect. What did Congress want to see happen
well, there
versus
was
what
two
is actually
things. There was
happening?
two things when Congress created the Sentencing Reform Act of 1986, 40 years ago. There were many things that it directed the commission to do, but two in particular. One was to craft the guidelines in such a way that first-time nonviolent offenders that did commit an otherwise serious offense received a sentence other than probation. Excuse me, received a sentence other than imprisonment. That's what they directed the commission to do. Make sure first-time nonviolent offenders could get a sentence of probation or an alternative, such as home confinement or something like that. That was one big directive. And then another big directive that they gave the commission is, hey, when you're doing these guidelines and you're sending people to prison, all that stuff, make sure there's room at the inn. Watch the BOP, work with the BOP, take prison capacity into consideration when you're drafting these guidelines, when you're promulgating them. What's the impact? What's the real world impact? Because we only have so many prison beds and et cetera. Commission never took either of those directives seriously, or I should put it this way, never took them into serious consideration when crafting the guidelines. It wasn't until 2 years ago in 2023 that even the commission gave that first directive about nonviolent first-time offenders a little bit of consideration when it passed the zero-point offender act, or zero-point offender adjustment. And you and I have spoken about that quite a bit. And that, for those with 0 criminal history points, that gave you a two-level reduction off of your total offense level. And that helped. And they also included a downward departure for those that received that particular adjustment. And it said in this downward departure provision that if you got that adjustment, even if you were in Zone D, and I will talk about that here in a second, even if you're in Zone D, the court should still consider a downward departure to a non-custodial sentence in appropriate cases. And the reason why the commission finally did that, not only because there was a directive from almost 40 years prior that told them to do that, and they were finally getting around to it, but their own empirical research showed that those with 0 criminal history points, they had a very, very low rate of recidivism compared to those even with just a single criminal history point, and so on and so forth. So they finally took a step into that direction, but then just last year they got rid of all the departures. So you give with one hand, take most of that away with another. But so now what they're considering doing, and this is huge, because it kills two birds with one stone, so to speak, because it's going to take care of both that. It addresses both directives, even though they haven't said in their reason for this particular amendment I'm going to talk about, they haven't said that one of the driving purposes is the prison population or overpopulation crisis that has always plagued the BOP, but it's going to take care of that. And that is the changes to the zones. And so I'm going to share my screen here for those that are home or wherever in the office watching this. So this is the familiar sentencing table, or this sentencing table everybody should be familiar with. You have your offense levels on the left-hand side and your criminal history category. Now, once Booker came into place, everybody kind of forgot about zones because the guidelines were only advisory. Judges could depart as low as they wanted, give any kind of sentence they wanted, whether it's straight probation, even if you're in Zone D, sometimes you would get straight probation or a split sentence. The zones didn't matter anymore in light of Booker. But as you and I know, judges still are primarily anchored to the guidelines. If you look at the average guideline minimum and the average guideline sentence, the average guideline sentence is always below the average guideline minimum because of the high rate of departures variances, but they still follow that same path. So there's still an anchoring effect there. So what the commission is proposing to do, as you can see here on the screen, is greatly expanding Zone B. So let me explain the 4 different zones. There's A, B, C, and D. A, the presumptive penalty has always been straight probation, period. You don't need any prison for these people because
which by the way is a unicorn in our in our defense world.
Yes,
It's almost never will those guidelines come out. You have to be a level 8 or lower to be
you're right.
in.
And
I,
almost
I'm
nobody gets that.
I'm trying to remember the only cases I ever recall ever being that low were mail theft cases back when I was a federal defender.
Or Class A misdemeanors, those
Yeah.
rare Class A misdemeanors. So,
Yes, but they don't charge those too often. But
right.
yeah, as far as felonies go, the
As
point
far as
is
felonies, yeah.
nobody freaking gets probation in federal court, even now. But
What you
and
mean
that's
zone A? You
well,
mean very few
it's
people are in zone A, but
very few
right.
people are, yes, very few people are in zone A. I can't remember
Yeah.
the last client I ever had that came out into zone A. So, but go ahead.
And very few people are getting probation. I mean, that's the
And
bigger,
very few, yes,
yeah. And
exactly.
even those that qualify for probation, you would think that close to 100%, if you qualify for probation, then,
Yeah.
you primarily should get if you qualify probation under the guidelines, like in other words, if you're in zone A.
Yeah.
But even there are many individuals, around 20-30% of those in zone A are still getting prison. And so that raises a big point here, a big mistake that the commission made when it first promulgated the guidelines is it focused primarily on one type of sanction. That, when you're sentencing somebody, there are multiple sanctions you can give. There's a fine, there's home confinement, there is community confinement, there's what's called intermittent confinement, where
Hmm.
you have to spend your weekends in the local jail. That's
Hmm.
available as a sanction at the federal level. Then there's split sentences, where you serve part of the time in prison and then the the rest of the time in like a home confinement or a community confinement or something like that. There's
Yep.
not just prison. And where the guidelines, I think, went astray, and they didn't emphasize, they focused only on one sanction, prison, and they did not give enough weight to all these alternatives. Now, in
Hmm.
fairness, over the years, the commission has had seminars, symposia, has published our reports about alternatives to imprisonment, and tried to encourage judges through various little amendments here and there and the application notes to
Yep.
consider it more. But that has never been enough. Bearing a little mention in application note 22 to some obscure guideline is not going to get a court's attention, and obviously doesn't work to motivate judges to use their discretion to impose alternatives to imprisonment. And that, as a result, has led in an explosion of inmates in the BOP, which is always, the BOP has always chronically been over capacity. It has always housed more inmates than it was designed to hold. And that's to say nothing of the crumbling infrastructure, piss poor management, low employee morale, not enough employees, not enough corrections officers, which leads to making it dangerous and all this other stuff. You and I have talked
Hmm.
about that ad nauseum and
Hmm.
other things. So at any rate, so what
Yep.
does this do? So getting back to the zones here, the biggest thing, so zone A, the presumption is probation. Zone B, the presumption also is probation, conditioned on an alternative to imprisonment. So you're not going to get straight probation per se. The presumption is you're going to get probation, but might get 1 year of probation, 6 months of home confinement, something like that. So you're going to have to serve home confinement while you're on probation. Point is, you're not going to prison. Zone C is your split sentences, where one half is served in prison, the other half is an alternative. And then finally, zone D, the presumption is your entire sentence is served in prison.
Yeah.
Now, traditionally, until as of right now, zone D begins at offense level 14 for those in criminal history
Yeah.
category 1, as you can see here. So, that,
And by the way, we
so,
can't necessarily see the bottom part of that chart, but
oh,
that goes up
okay,
to from level 14 all the way to
there.
level 43. So as you can see, almost the majority of the existing sentencing table is zone
Right.
D.
All basically all of this going up here a little
Yeah.
bit, that's all zone D. So the bulk of federal defendants are in zone D. So this pink area is an expansion of zone B. So now, instead of ending at offense level 11, it's going to expand all the way up to 23. So
That's
they're
great.
basically doubling it, certainly doubling the
Yeah.
number, but it's going to capture more than double of
Yeah.
the defendants. It's going to capture all these people from 14 to 23 that are in Zone D right now will be in Zone B. So they're going to go from a presumption of prison to a presumption of probation. That
Amazing.
is huge.
Yeah.
Now, the commission, I'm not exactly sure the methodology. Well, I know for mostly what the methodology was that they used, but they estimate that about 6,500 defendants that were sentenced under this chart as of 2024, if that chart had been in place if this chart had been in place in 2024, these amendments, 6,500 would have been in Zone B, which with the probability that most of them would have received straight probation instead of prison. So they're in prison right now. When with the zone change, they would be out. And what's really important, what we write about in our article, is the minimum security facilities, which make up the bulk of the Bureau of Prisons. There's, I think, 181 active Bureau of Prisons facilities right now. Well, maybe it doesn't make up the bulk. Well, it's the largest group, largest security level are the minimum security facilities. You have the minimums, lows, mediums, and highs. And the minimums, there are 67 of them, which is the largest group. And they right now have grown in terms of the average prison population by over 20% just in the last 5 years. And they're closing in on their maximum. Right now, out of the 67 facilities, 9 of them are they're at over 100% of their capacity. And that's continuing to grow. The Trump administration and the Biden administration have closed 10 of the minimum security facilities over the last few years, and 2 more are slated to go offline this year. And that means, what that means is there's less and less room at the end, which drives up the prison population. More of them are going to be over capacity, causes all sorts of, it's a cascading effect of horribles, if you will. So this is going to help significantly. And what we estimate, what we write in our article, is that this will save the Bureau of Prisons about $170 million a year, just, by the way, just for economic offenders. And we have an analysis in our article just on those sentenced under 2B 1.1, which is the fraud guideline, primarily when I call economic offenders, usually people call white collar offenders. So the white collar offenders out there, most of them now will be moved from a presumption of imprisonment to a presumption of probation. So therefore, it's going to reduce the load on the Bureau of Prisons and the associated expense. It's costs around $43,000 a year on average for the Bureau of Prisons to house an inmate. It's a few dollars a day for the Bureau of Prisons to monitor somebody on home confinement, and they don't have all the associated costs with, the infrastructure and all that other stuff. That's all borne by
so
the inmate.
I have 3
Yep.
questions I have to answer. I
Yep.
have to have you answer. The first question is, what are the odds that this actually passes?
Yep. Answer that now. I think the odds are quite high that this is going to pass. It might be modified a little bit. And I'll be honest, when I saw that Zone B, how big it is, how much they're proposing, I was like, holy shit. Now, this is consistent with the changes that the commission has been making over the last few years. There have been a lot of defendant-friendly changes to the guidelines in terms of moving away from this presumption of imprisonment.
Mm-hmm.
And there have been, more downward adjustments. I know we're not talking about them, but there is some additional downward adjustments that the commission is proposing for post-offense rehabilitation and modifying sophisticated means, making it more difficult to get. So that two level bump, not so many of the white collar defendants will get now if that goes through. So, but the point is, it's very consistent with away from lengthy terms of imprisonment and imprisonment as a sanction altogether. There's been a move away from that. So I think there's a strong likelihood that this will pass, but maybe not with such a large Zone B.
Okay. And by the way, I do want to talk about post-offense rehabilitation for a minute when we've done with this, but I still have 2 more questions for you.
Okay.
Second question is, Would it be made retroactive?
That I doubt. And as much as I would hope it would be made retroactive, I just don't see the commission doing this mainly as a result of the enormous burden it would put on the courts now and the public defenders out there, let
They
alone
basically have to
the U.S.
resentence
Attorney's
every
offices.
single. They'd have to
Yes,
resentence every single person in the BOP right now.
yes, they would have to resentence pretty much
And
every
how
single
many
person,
people is
other
that?
than
Like,
lifers.
is that 100,000 people they'd have to?
There's, as of yesterday, I think there's about 130 something thousand
Yeah.
in the BOP.
137,000 resentencings, and
Yeah.
and no U.S. attorneys anymore because they all quit.
Right.
So
Right.
okay, so that's sad. You don't think
Yeah.
so? So it's a logistics thing, which is a
Yeah.
bummer because I don't think
Yeah.
logistics or time or cost should really be a consideration.
Oh,
when
but
you're
guess
talking about
what,
freedom.
though? Guess
Yeah.
what? Guess
Yeah.
what?
What?
It now could be used as a ground for compassionate release.
Oh, okay. Interesting.
I didn't graduate at the top of my class
But
grade. I didn't
isn't it?
graduate at the
But
bottom.
we're gonna have to do another podcast on this. But isn't there a pending Supreme Court case that's going to limit the grounds for which compassionate release can be invoked, or no?
Oh, limit or expand?
Limit. I thought it was limit. I thought it was
It could
no.
go either way. I mean,
Oh,
the petitioner in that case wants it to be
wants to
expanded.
expanded. Okay.
Yeah.
So this may be grounds for compassionate release, but this
Yes.
really, I guess, this probably dovetails quite nicely into my third question, which is, assuming it passes,
Mhm.
how are judges going to implement this? Because remember, fundamentally, these are advisory guidelines.
Right.
And we know from the last set of changes, we're now simplified into a two-step process. Let's look at
Right.
the guidelines, see what they say, and then let's bop on
Mhm.
over to 3553 and take in
Mhm.
all those factors of sentencing, history and
Yeah.
character, nature and circumstance, everything else,
Right.
and figure out what the judge will figure out what the sentence should be. So,
Right.
the argument can be made, putting aside mandatory minimum sentences, since Booker, judges have always had the option to go give probation in any
Correct.
case, and
Correct. Right.
deviate. We call it
Right.
vary, downward
Mhm.
variance, as many levels as they want,
Right.
and they don't do it.
Right.
And presumably the reason why is maybe because the guidelines say, these are what the guidelines say, but there's also a possibility that they've just analyzed all the factors and decided this person deserved to go to prison for X amount of time for the thing that they did. And so now the advice is going to be different. And the question is, to what extent will they follow the advice
Yeah.
of the guidelines, especially when you consider this whole notion of sentencing parity? How
Yeah.
much are judges going to bristle and say, well, I've sentenced the last 100 defendants to prison, and I thought those were fair and appropriate, no greater than necessary to achieve the goal of sentencing, and now the guidelines are telling me I shouldn't send you to prison, but I sent all those to prison. Wouldn't be fair if I didn't send you too. Like, I'm really worried how this plays out practically.
Yeah. Yeah. And I think that's a legitimate worry. And I think that the answer to that, Judge, is this is what the guidelines now say, and you should take that into consideration. I mean, certainly in a case like this, if I had a client that was in Zone B, I would say, yeah, you do not need to put this client in prison. The government's going to say, we'll make your disparity argument and say, well, look, Judge, whenever the law changes in favor of a client, the government always says that you can't take advantage of that.
Yeah.
But this is a time where the law has changed in favor of a client, and there's good reason for it. There's good reason not to put him in prison. There's no room, and it's not necessary. And that's what the commission, an expert agency that has had all these hearings and has received all this data and has done all this scientific analysis, has come up with.
Yeah.
And if you go to the commission's website, by the way, they do have it's a little video that they put up there going through a lot of these recidivism issues. And as it turns out, those individuals, and if you notice, if you're looking here at the revised sentencing table that's up on the screen, you notice how big zone B is for criminal history category 1, but then it gets much smaller for 2, 3, 4, etc. on
Yeah.
down. And the
Yeah.
reason why is those individuals in criminal history category 1 have a very, very low rate of recidivism.
Yeah.
Little to no prison is enough
Yeah.
to deter most of them from committing criminal conduct again, whereas that's not the case for 2, 3, and 4,
Right.
5, and 6.
And
So
also
there's
it's in
science to
line.
back this up.
Yes, and it's also in line with the original intent, which is first
Exactly.
time
Yes.
non-violent offenders shouldn't
Right.
go to prison. So the
Exactly.
argument is, Judge, I know you've been sending all these people to prison, and I know the guidelines have said that, but that was never supposed to be the
Correct.
way this was supposed to work. And thank goodness it only took 40 years to come to, to realize what everyone should have realized
Yeah.
at the very beginning of this. And
Right.
now it's time for a change, and change is hard. But man, 40 years, 1986. When you said 1986, I was thinking about what was I doing in 19 Life was so simple in 1986,
High
man.
school. Yeah.
I just got my driver's license, was
Yeah.
cruising down the street in my little Honda Civic. God damn, I was bagging groceries at Joe Amalia's food market, had my little high school girlfriend. Everything was right with the world, man. We hadn't
Yeah.
been to war. We hadn't been to war in Iraq the first time or the second time. We had no 9/11, no nothing.
MTV still played music.
Trump was still just doing cocaine and real estate deals.
Yeah.
Oh
I don't
my
even think he
God.
really was on the scene back then outside of New York City.
Well, he was an 80s guy, but no, he wasn't. I want a time machine. I want to go back to
Hmm.
1986, playing my guitar, staying out late, drinking Little Kings. You remember, did you have Little Kings down there in
Little
those little
Kings.
tiny beers in the green bottle, Little Kings?
We had Mickey's Big Mouth.
Oh,
I don't know,
all
something
right.
like that, man.
California coolers, Bartles and
We
James, the
had we
wine
had Bartles and
coolers.
James. Oh yes,
Oh
I
my
remember those.
God. 1986, man.
Great for a hangover, I'll tell you.
What a great time. Okay, I got lost. Wait. Okay,
Okay.
so we have 10 more minutes, and I do want to spend. So again,
Yeah, third
the other
question.
yeah, no, that was the third. The first
Oh,
was will it pass, second retroactive, third is
okay.
how are the judges going to implement this.
Oh,
So
got it, got it, got it.
so this is the big one. Like the I'm coming to join you, Elizabeth, big one. And
Okay.
so we'll have to just see what happens. But I want to encourage everybody, and we'll put a link in the show notes to go to the commission's website and
Yep.
comment on this and tell them, yes, go dog go. This is the
Yes.
big one. I'm coming to join
Yes.
you, Elizabeth. You know what I'm quoting, right? Sanford
Oh
and
yeah,
Son.
Sanford and Son. I love
All right.
Sanford and Son.
You big
Yeah.
dummy.
Yep.
Anyway, anywho,
He
but the
just died,
last
by the way, the big dummy. Lamont. Yeah.
Oh,
Said it. Yeah.
bummer, man. So, like I said, we talked about some of these other ones, a lot of economic crime. So, white collar offenses are pay big attention because there's a lot
Yep.
happening. This one is for white collar, but really for everyone, and it's one that I'm near and dear to my heart. So, I wanted to give it a few minutes, which is the post offense rehabilitation amendment. What are they proposing to do there?
Well, basically, depending on your conduct after you've pled guilty or been found guilty while you're awaiting sentencing, is if you engage in any type of pro-social rehabilitative behavior or endeavors, that should be considered. That should be given a consideration under the guidelines, a reduction in
Yeah.
your total offense level, and they're toying with anywhere from 2 to 4 levels for that, depending on how much you engage in. Now there is objections have been made to that because what about those clients, those defendants that are in custody?
Wait,
Their
I'm sorry.
opportunity.
Back up. You said
Yep.
they're proposing how many levels?
2 to 4, if I
Two to
saw that
two to
correctly.
four. Okay,
Yeah.
that's not small potatoes,
No.
especially when you talk about these zones changing. But go ahead. So,
Right.
yeah, you raise a very good point, which is injustice. The problem is for our clients, many of them are not released pretrial to bail, to be at home. And it's much easier to go to counseling or do community service or,
Hmm.
all the things that can show that you're making. And by the way, these are what we call our redemption stories. If you've been paying attention to us for the last 3 years now, I think that we've been doing this, you know that we have the 3 R's of sentencing mitigation, and that's an article that I routinely share with people, and I'm going to put that in the links. But one of the sentencing stories we tell is a redemption story. What have you done to redeem yourself from whatever bad act whatever mistake that you made? Because a person's
Hmm.
life is not going to be defined by their worst mistake. It must be defined by the totality of their life's work. So post-defense rehabilitation says, this is what I've done to
Right.
set the ship right and make amends for what I did. And when you're in
Hmm.
custody, you're in these
Yeah.
pretrial detention facilities. They barely have any programming, counseling. It's really, really hard to demonstrate rehabilitation besides what? Not getting in trouble, not having
Right.
a
Yeah.
disciplinary
Hmm.
infraction, which is expected of you. So
Right.
the question is how do we help if this thing passes? It's not fair. It's easier for out of custody. How do we help our in custody clients take advantage of this very important provision?
Yeah. You argue for a variance. Say on that ground, it's not fair. But yeah, before we
Well,
started the
you
yeah, go ahead.
argue to get them out, and
Right, yeah,
that's
right,
one more
exactly. That
reason. That's
like
one more
there's more
reason
reason, right?
to
Yeah.
get to give them bail. That's one thing. The other thing is, I mean, there are even listen, you got to get creative. I have a client who is in the pod with all of the non-English speakers for some reason,
Mm,
and he's just on his own teaching them English, just hanging out with them in the day room and helping them learn English or
mm,
helping them read their paperwork because they don't know or
yeah.
communicate, like these little things. And then you're going to have to get people to write letters on your behalf to explain to the judge all the help and wonderful things that you've done inside, right?
Hmm. Right.
Ideally, and we talked about this a little before, but ideally, if the government is paying a facility to lock up our clients pre-trial. They contract sometimes with local jails or private facilities like CCA. Why on
Hmm.
earth can't the feds say, as part of our contract, we're paying you to house our federal detainees, pretrial detainees. As part of that contract, you will provide them with X, Y, and Z in the way of services, counseling,
Right.
drug
Right.
treatment,
Right. Yeah.
psychological
Great idea.
counseling, educational. Give them those freaking tablets so they can do those courses,
Yeah.
which I am seeing more and more. So there
Yeah.
should be, in an ideal world, there should be opportunities for even our in custody to take advantage of this. But this is the practice pointer. Whether you're
Yeah.
in or out, get to work, man.
Yeah. Yeah.
I mean, we've been telling our client, this is long before the commission ever talked about codifying this. We've been telling our clients this from the get go. You know that you've got this is defending your life now, and everything that you do matters, and you need to bend over backwards, even if it's getting a job at the local Burger King and putting away $10 from your paycheck towards a restitution, and you may owe $1 million restitution. But if you walk into sentencing with a check for $500 because you've been working at the Burger King because that's the only job you can get, that means something to the judge.
Right.
Everything you do matters. And now the commission is really putting an exclamation point on that truth that we have known to be true for so long.
Right.
And so that's, of course, part of what we do when we represent our clients. We get them started down that path and find and help them find opportunities. And the last sort of practice pointer is, and this is under my 3 R's. If you read the redemption part, there's what we call future redemption stories, which is to say,
Mm,
if you're in custody and your options are limited, they really can't, then you have, and especially your lawyer has to help you
yeah.
with this.
Yeah.
They have to have you take concrete steps to formulate a future plan to show the judge that you're
Your
giving.
release plan, basically.
Yes.
which helps
And
with compassionate release motions too, by the way.
yes.
Yeah.
And it could be your BOP plan. Like I've researched thoroughly the facilities, and I know this one has a opportunity for me to earn my commercial driver's license, and I've
Mhm.
always wanted to do that. So I'm asking you, Judge, please send me there because this is what I care. I want to rehabilitate, and
Right.
I'm limited now, but this is my plan, and I've done the homework to show you that I'm serious about this.
Mhm.
You've got to think about what comes next. Where are you going to
Yeah.
live? Who are you going to live with? What will your work be? Do you have a counselor ready and lined up, ready to take you in and help you work through your trauma issues and your substance abuse? You know, all
Yeah.
of these things we don't always think about, but they matter always. And now they're really going to matter because there's a guideline you can point straight to.
Yeah. Well, hopefully
Anyway,
there will be. Yeah.
yeah, hopefully.
Yeah.
Well, this one seems like an easy one to pass, don't you think? Or no? Weren't they
Yeah.
talking about this? How they shouldn't? I was watching something at the hearing where somebody was saying, just leave it. Oh, yeah, yeah, yeah. Because remember, there was this debate, and I don't remember who it was, but who was saying, the guidelines should be left to the very easy, well-defined calculus. Loss amount is a well-defined,
Yeah.
these things that are concrete, and
Yeah.
that these sort of nebulous things like rehabilitation should just be dealt with over in 3553 and leave it there. Don't muddy
Right.
up the guidelines with stuff that's not that's less than concrete, and I don't know. What do you think about that argument?
I think there is, academically, intellectually, it's a good point because, but it goes both ways. I mean, one of the other things that the commission is toying with is adding into the loss calculation non-economic harms, like pain and suffering. Well, how do you do that? I mean, juries have a tough enough time coming up with that in civil proceedings. Now
Yeah.
you want a judge to do it for purposes of determining how long someone goes to prison. Ugh.
Yeah.
So that's, when you start to get into more qualitative as opposed to quantitative measures, yeah, there is an appeal to that argument. But nonetheless, I think here, maybe 4 levels off it should be reserved for like really extreme post-offense rehabilitation. But, a standard 1 or 2 levels off, I don't see
Yeah.
that big of a deal if a defendant can prove it. I mean, that
Yeah.
this is going to be the onus is on the defendant to prove this up. So, I think that fact with putting the onus on the defendant to prove this up kind of negates that, I think, legitimate concern about this being more of a qualitative than a quantitative measure.
Yeah. Well,
So,
we'll see. We'll see.
yeah.
I like this one though. So I think
I like it too. I think
I
it's great. And yeah.
yeah. And I'm excited to see what happens. So I will again reiterate: go to the links in the show notes and send comments. And people need to hear from our community, either in the legal side or in the client side or the people side. People are
And on the
clients.
Sentencing
Clients are
Commission's
people.
right. And on this
Lawyers
Sentencing
are
Commission,
arguably people as well. But
you're I
you know what
used,
I'm saying? It's Friday
right,
night, Friday
right.
evening, and I
This just
still haven't
reminds
had
me of
my
a quick
tequila.
joke I remember from law school when I lived out in DC, and everyone used to say, Washington DC, it's the only city on earth where there are more lawyers than humans.
Hmm.
Anyway, so March 18th is actually the deadline for comments for
Okay.
this second series of proposals that the commission is giving. And there's a portal. You could submit your comments on the commission's website through a really easy link. If you just go to the commission's homepage at ussc.gov, you'll find right there a link to where you can
Yes.
make comments.
Go there, but I'll put the link on our show notes as well, and I'm going to put the 3 R's over there in case anyone wants to read that article. And I will say, if you've made it this far, we are at our 1 hour. We did great. I'm waiting for my little friend to come. But if you've made it this far, you're a diehard fan, and I hope you have liked and subscribed and shared the show. Our audience is mighty and growing every day, and our goal is to get as many people, informed about the process as we can. So please like,
Yep.
share, subscribe, do all that stuff. And as always, Mr. Allenbaugh, thank you for spending your Friday afternoon and sharing your great wisdom, your great guidelines wisdom. And we will do this again quite soon.
Great. Well, thank you, Doug. It's a pleasure.
Was it really a pleasure, though? It was fun for me.
It was fun. I'm starting to get pooped.
That's it for today, but before we go, I just wanted to take a moment and say thank you. To you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.